The Evans Family Law Group, providing a full spectrum of family law services.
Under the new statutes, in the event that a father can establish that he was precluded from getting a DNA test as a result of fraud, for example, and his parentage is rescinded or struck by the courts, the issue always comes up about what happens in the event he had previously been ordered to pay child support. What happens to that? In the event, for example, it was a divorce, or if it was just a custody suit where that had previously happened a year or so before, and he was under a continuing court obligation to pay child support. And let's say that he realizes a year or two later about the fraud, he meets that burden under the statute, and the court agrees and orders a DNA test, and lo and behold, it comes back and he's excluded from being the father. But he owes 2 years' worth of child support. Well, our legislature decided in their wisdom that you still owe that child support. Unfortunately, being excluded as the father does not exclude your obligation under that existing court order. And so the courts cannot waive or lower or modify that period of time, in this example, 2 years of what you owe. So if you're current, that's good, because you won't owe, going backwards, what we would call arrearages or a judgment for arrearages. On the other hand, it does terminate your obligation going forward. So from the time that the paternity is terminated or rescinded, if you will, under that new court order, based on the new DNA results, your obligation to pay child support from that point going forward is canceled or terminated. And so there will no longer be an obligation to pay current child support. The other interesting aspect about that, it's a small nuance, but it's important. Typically, your obligation to pay current child support, whatever it is per month, is enforceable in the nature of what's known as contempt, meaning the court can threaten and actually imprison you for a period of time for failure to comply with the court's order to pay your child support. What's interesting is that the legislature decided that under this particular statute is that you can get your judgment for, say, 2 years of child support that you owe, but it's not enforceable in the nature of contempt. So it is enforceable as any other civil judgment would be. You can go after non-judgment exempt assets, but you cannot be threatened or you cannot be imprisoned for not paying that particular judgment.
When life's path takes an unplanned turn, call the Evans Family Law Group for a consultation at 628-2550. The Evans Family Law Group, providing a full spectrum of family law services.